Hey guys, this is Roxann Smithers with Smithers and Ume-Nwagbo, and this is a note from my Legalpad. So this is part 2 in our series as we're discussing business divorces. In part 1, we talked about withdrawals or buyouts of a business when an individual is leaving, whether voluntarily or involuntarily. So this is part 2, where we are going to discuss if a new partner or member comes into the business organization, basically substituting in for that withdrawing member or entity. Again, this can happen voluntarily or involuntarily on either side. So you can have a member who wants to withdraw and wants to sell their interest in the business or their interest in a partnership to an outside new third party. Or you can have a situation where the business wants a new member, wants a new partner, and they want to substitute out another partner. Or this can be mutual, where the parties have agreed that on a third party that is going to purchase the withdrawing member's interest. And these things can happen for any number of reasons, whether it's on good terms or it's acrimonious. And so you have to think about how it's going to work. Again, the first thing that you're going to look at are the terms of the agreements between the partners, whether that's a partnership agreement or an operating agreement. And if in the unwise event that they do not have a partnership agreement or an operating agreement, then they'll turn to the state statutes that govern partnerships and that govern limited liability companies to determine the process for a new member coming into an entity, particularly in the situation of a substitute of an existing member. So there are a couple considerations that play into effect when you're looking to substitute in a new member, whether it's a voluntary situation or it's an involuntary situation. Particularly on the side when the member is looking to sell to a third party, oftentimes your partnership agreement or your operating agreement is going to give the business entity itself or the other members of that business entity a right of first refusal. What that means is they have the first option to purchase those shares and purchase that interest in the business before they're sold to a third party. They may even have an opportunity to get a favored pricing for that. That can either be a set amount that's agreed to within the partnership agreement or the operating agreement on how much a interest buyback will cost, or it can be some sort of discount on a viable offer that the member who wants to withdraw brings to the table. For example, if the withdrawing member finds a buyer who wants to buy their interest for $100,000, there could be a 10% discount that they have to offer to the members of the business or the business itself, which means the members or the business would only have to pay $90,000. And they'd have a certain amount of time to exercise that right. And then the exiting person has to sell to them for the $90,000 as opposed to selling to the outside party for $100,000. There are also often provisions in a contract, both your partnership agreement or your operating agreement, that that limit the ability of a outside party to come into the business without the permission of the existing members. There could be a majority rule that is required. There could be a vetting process that is required. There could be any number of approvals or obstacles that have to be tackled before a member can be added to the business and added as a member of the business. And there may also be designations given to whether that member comes in as a full-fledged member with voting rights and management rights, or if they're simply coming in as an income or revenue member, meaning they just have some shares, and if and when there are distributions, if and when there are profits to be shared, if and when there are losses to be taken, they participate in that part, but they don't participate in the management of this business. More often than not, we see that when we purchase stock in our favorite companies. Just because you own some shares in Target doesn't mean they're going to be checking in with you to decide what they're going to do next in terms of their corporate strategy. We just have a financial interest based upon that ownership interest that we have, those shares that we have. Then you want to look at what is going to be the actual mechanism for this substitution or for this individual to come in. So you can have a direct transfer between the exiting member and the new member, meaning those two parties would also have a purchase agreement, and the shares and interest would be exchanged between the two of them, and payment would transfer between those two parties. Or you could have a situation if there may be a new partner, may not be a new partner, or the company's trying to decide on a new partner, or they're going to change the amount of interest that new partner gets and they're going to do a mix. You can have where the withdrawing member transfers their interest back to the company. The company then pays whatever is agreed upon price. And then the company then issues new interest and membership to the new person. And it can be at the same price, or the company can be looking to make a profit. So for example, you could have a company with a 10% right of first refusal discount that decides that they are going to purchase the shares back from their withdrawing member for $90,000 and then sell those shares to the new member for the full price of $100,000. And now the company has made a $10,000 profit by simply letting the member out. Or if there are other discounts in the partnership agreement or operating agreement in terms of the pricing internally, and the company has an opportunity to possibly make a profit by selling the shares back out to a new person at a higher market value. Those are things to take into consideration when substituting in a new party. Speaking of pricing, you'll also have to decide if your operating agreement or partnership agreement doesn't decide on a price. There may be a formula in there that can easily be applied by the parties or by their CPA. Or you may have a situation where you have to get an appraisal or evaluation for the business to really understand the value of the shares that are at issue. And then the buyout and the resale are going to happen on that basis. In any event, it's very important for the parties to discuss all of the issues, to plan out a substitute, and to really be clear on what's going to happen going forward. And just like in part one, you'll probably have both a disassociation agreement. There will also be a sale agreement, either directly between the withdrawing member and the new member, or between the company and the new member if you do sort of an indirect sale. And again, you'll have to decide on how to handle liabilities of the business that existed before the substitution, that exists after the substitution, handle the distribution of any assets going forward, and decide on any modifications to the share structure between all of the members, what percentage of the business the members are now going to own if that changes, and what role this new member may have in the business. And if there is cooperation on everyone's side and adequate planning on everyone's side, you can definitely have a substitution of a member that will be a smooth process and a happy transition for everyone. So for more information from attorneys at Smithers and Ume-Nwagbo, you can reach us at stulawgroup.com. You can reach us on Facebook as well as LinkedIn. And this has been a note from my Legalpad.